Yeah, sure. Yeah. Okay, very good evening, all lovely people. Welcome. And on behalf of eWIT, I welcome you all to an exciting hour where we have lined up speakers from ISACA Chennai chapter. As we all know, data is a new oil, and it's crucial that we understand about data security and the privacy aspects. We have, chosen this topic. So before we dive into the session, to introduce eWIT, I would like to invite Uma Shri Raghunath, President eWIT, to do the honors. Over to you, Uma.
Thank you so much, Sunita. And it's such a pleasure and honor to have our friends from ISACA here today, along with eWIT. eWIT has been an organization that has started actually as a part of STPI Chennai and later on moved as a separate entity so that we can focus on the issues of women in IT and ITES industry. We have been doing very primarily addressing women issues like work-life balance, post training, then providing support for their upskilling, reskilling, training needs, enabling the ICC committees within the organizations. And later on, we also started conducting a lot of webinars and seminars on specific technologies that are relevant for women. And today, in a new dimension of eWIT, we are looking at making women leaders in the IT and ITES industry. How much ever we try, we still see that the percentage of women in the pyramid of growth is very less compared. And today, eWIT is trying to actually enable women to come up and take up more challenges, more opportunities, because we, with our intuitive management skills and niche for the innovation and technology, we can think and do enough and better if given a chance. So this whole eWIT is reinventing our own wheel with thoughts of entrepreneurship, thoughts of innovation, thoughts of actually networking more and making women leaders. And I am sure ISACA has been a wonderful partner with us in actually bringing in the awareness on cybersecurity ever since eWIT started. And we are very privileged to have one of the pillars of ISACA, Jamana Swami, also as our life member. So that's the strong connect that we have, that people connect makes a lot of difference. And I think that is where we are heading to. Today, we have wonderful speakers, Chuda, Mani and Sangeeta. Welcome to you both. And over to you for the rest of the session. Thank you all.
Thank you, Uma. So now may I request Mahesh Balakrishnan, Director Programs, ISACA, to talk about ISACA. Over to you, Mahesh.
Yeah, good evening, folks. Good evening once again. Just wanted to go ahead tell a little bit about ISACA. We are a professional membership organization with focus on digital trust, right, for IS and IT professionals. So we have been serving the professional IS IT community for more than 50 years, sort of leading the industry in career advancing, as what Uma she alluded, right? Career advancing credentials like CISA, CSIM, and other credentials as well. We are a 170,000 member organization with 225 chapters worldwide and present in sort of 188 countries. And here we are based out of Chennai as well. We call ourselves the ISACA Chennai chapter, right? What do we do? I mean, we continuously sort of address the technology challenges of global enterprises actually. So, right, and then we provide enterprise performance improvement solutions, tailored team training, and industry-leading frameworks in terms of ISACA Global. I'll just tag team my colleague, Vaidyanathan, who is the president of ISACA Chennai chapter, to just point a few words on ISACA Chennai chapter. YD, please.
Thank you, Mahesh. And it's my pleasure to connect back with eWIT once again. I do remember we did one program sometime back in STPI, and I was part of that program. Good to have you back again with all of you. Very good evening to all. Just to give a background about ISACA Chennai chapter, as Mahesh mentioned, we are the first chapter formed in India way back in 1986, and we have been helping our members in upskilling, reskilling, and whatnot. We help our members in preparing themselves for the various ISACA certifications. We also ensure our members get their continuous professional education credits, which is a mandate for our certification. So we help our members, and we partner with a lot of industry bodies, training institutions to continuously, engage our members with training. And our annual conference, it's a 3-day affair, and it is, one of the best conferences. That's a feedback we keep getting. No other chapter does a 3-day conference sort of a thing, in this domain. And we have been doing that for over 15 years now. So that's what in a nutshell we do. COVID in a way helped us in transforming, from physical only mode to virtual, and also the hybrid mode of reaching out to our members. And our engagement with members also increased, because of being a virtual event. And I'm sure eWIT also will have the similar thing in terms of, virtual will have a better reach. And we may also bring speakers from outside of Chennai so that, the members get a better value. With that, I don't
Absolutely,
want to
Mani.
thank you, Umasri. Good to connect back again. So
Mani.
with that, I would hand over back. We have an excellent session ahead. So looking forward to hear from Chodamani and Sangeeta for the next 45-50 minutes. Back to you. Thank you.
Thank you, Mahesh and Vaiti. We are privileged to have you all here. So now I would hand it over to Esther for introducing today's speakers to the audience. Over to you, Esther.
Thank you, Sunita. Very good evening to everyone. It's my immense pleasure that I have the opportunity to introduce very expert members here. Ms. Udamani, an FCA, CISA, with about 20 years of experience, both in industry and in independent professional practice. She started her career with a stint in ESA International, leading a team for international trade operations for the European region. As a partner in audit firms, she has been in charge of internal and statutory audits. She has done information systems audit assignments for associates like Quarit Private Limited, Pristine Consulting Private Limited, and her experience spans across areas like development, testing, and implementation of information systems in the banking and manufacturing verticals, ISMS compliance checks, and data privacy audits for GDPR compliance. On the academic front, she is a subject matter expert for Connect, an online academic platform developed and maintained by SPI Technologies Private Limited for North American and other international universities. She is a faculty at the ICAI for the AICI TSS Advanced Technology course. An ardent advocate of the ESG approach to corporate deliverables, and has now ventured into this area and looks forward to interesting assignments. We welcome you, Chodamani.
Thank you.
Sangeeta. Sangeeta is a CISA with around 17 years of experience spread across multiple domains. She holds the Lead Auditor ISO 27001 and Lead Implementer certifications for BS 10012 PIMS, including GDPR. She started her career at the World Bank with financial reporting as the core function. Post a brief maternity break, she explored the realm of chartered accountancy practice as a partner in a CA firm in Chennai, handling various streams of direct and indirect taxation, statutory audits in the banking, hospitality, and manufacturing sectors. With constant learning as the watchword, she had migrated into the information systems audit and cybersecurity, supported by a stint at a certified firm in Chennai. With exposure in ITGC, ISO 27001 audits, predominantly in the BFSI sector. Her specializations included regulatory audits with regards to payment and settlement systems, insurance cybersecurity, vendor risk assessment, BIA, audit of outsourcing function, and audit of banking and insurance applications. MS General Insurance Company Limited as an internal auditor specializing in information systems audits. Besides being a director, special interest group at ISACA Chennai chapter, she is also the editor of chapters food theme-based quarterly newsletter Secure Tea Cafe to unleash her passion for writing. She loves to read, writes to learn, and strives to add value in all endeavors. We welcome you, Sangeeta.
Thank you so much.
Thank you, Esther. So I think the first speaker would be Sangeeta. So over to you. One request to the audience is please feel free to put your questions in the chat. We'll have a separate Q&A session at the end. Over to you, Sangeeta.
Thank you. My screen is visible, right?
Yes, yes,
Yes.
yes.
Right. Okay. Thank you for the wonderful introduction, panel, and a very happy evening to all of you present here. Thank you so much for joining in. Well, data privacy, personal data, PII, DPDPA Act, these are the terms we've been listening to quite often across the last couple of months. So today, it's not going to be any different, but Chudamani and I will do our best to make it as interesting, as engaging, and as informative as possible, as much as we can, with the humble learning we've been able to garner in the last couple of days. And we look forward to so much of learning from your side by means of the questions and ideas which you put forth during the Q&A session. So it'll be a mutual learning session is what I promise. So a bit of a disclaimer before we get into the core content. The views expressed in this presentation are the individual views of the speakers and do not in any way represent the organizations that they may be associated with or employed in. The views expressed herein are not to be construed as legal opinions, right? So here we go. Well, privacy is basically an individual concept. We all know that. We are very clear on how or whom we want to express our personal information with, whom we want to share our personal information with. We are very, very clear on that. And that is privacy as a concept. But last couple of years, if you would, just recollect, there's been so much of thrust across the globe also on, on the seriousness that is attributed to privacy. So, I mean, we are in a data-rich era. If you wonder, we are in a data-rich era. And Sunita was just mentioning data is the new oil. And we've been hearing this term across in so many forums in the last decade. It's the most cliched term, I would say. But then it is so true and it is so important at the same time, right? So when something is in abundance, there is possibility of data aggregation, correlation, and of course, misuse. So the regulators and even the country governments across the globe, they realize the importance of the need for a special act, a specific act for privacy by itself. And that is why we have an act which almost every country now does uphold specifically for privacy. And in every other forum, again, we get to have this question, like, is security and how different is security from privacy? Are they one and the same? Are they different? If yes, how? Well, my simple thoughts on that would be security will be securing data and privacy will be securing your identity. And here in security, the crown jewel is the CIA, your confidentiality, integrity, and availability. That is where the focus is all about. But then in privacy, the focus is on controlling the processing of your personal data. When I say processing, it's a whole gamut of activities. It begins from collection, storage, and then usage, and then processing, finally erasure, destruction. So it's a huge gamut of activities that kick off right from collection onwards. So privacy will be a subset of security. So this is the broad, aspect or thoughts on privacy as a concept. Moving on. No presentation is complete without statistics. Okay, so this is not an exception either. Now we have the United Nations numbers from December 2021 that 137 out of 194 member nations do have a legislation for privacy. Well, of course, the numbers as of date would have gone quite up, so I'm sure. But then some of the notable countries which do have a privacy-specific legislation are, as you see on the screen, you have the GDPR, which is so popular, which got enacted in 2018, with applicability across EU and EEA. We had the California Consumer Privacy Act of 2020, but then the personal data element was infused, and it was rechristened as California Privacy Rights Act, CPRA 2023. And then you have the Personal Information Protection Law, PIPL 2021 of China. The Federal Act on Data Protection had been there earlier in the 90s itself, but then in Switzerland. But then the personal data portion had been infused again, and it became revised Federal Act on Data Protection. Then you have a finer classification of personal data, which is PHI, Protected Health Information, which is specifically what Health Insurance and Portability, hence Health Insurance Portability and Accountability Act, HIPAA of USA speaks about. You have the SHIELD Act of New York, which also has personal data protection elements out there. And joining the league of countries which are very serious about protecting the privacy of their citizens, we do have India with Digital Personal Data Protection Act 2023 DPDPA. That's how it is called as. Well, by the time, this bill became an act, it was quite a wait, I would say, because in 2018, we did have the initial bill, and then it went in for a couple of iterations from the JPC, and then it got completely scrapped. We again got a new bill, and we finally now have an act. So it's been quite a wait, I would say. It is truly worth it because it's happy to see India along with the others in their drive for protecting personal information. And of course, here statistics again in a different genre. We do have personal data breaches that have been that had taken place in the last couple of years. Okay, so very recently there has been a breach of employee sensitive information of a PSU bank. So here we see the passbooks, names, address, PAN number, everything has got breached at one go by means of compromising one database. So we also see a couple of months earlier, the vaccine update website of the government has had a breach wherein your Aadhaar data, which does hold biometrics and also passport information, have got breached. If you look at the other three breaches, you might see a pattern. All these have taken place during the second wave of COVID in India. That is when your online grocery marketing and your, food delivery agent involvement or their businesses were absolutely spiked. Okay, so their order database, their customer database have got compromised at that point in time, leading to exposure of so much amount of personal data, which can be aggregated, which can be readily used in other platforms, wherever same passwords or informations which are required for authentication can be used for greater compromise, right? And if you see the online grocery, even the hashed passwords, they have retrieved. Obviously, you have mechanisms like Rainbow Table to unveil the password value and then get to more personal information by accessing the site of the grocery store. So these are few examples of personal data breaches that took place in India. So now the tone and the road is set, and we are going to come to the core topic of the evening, which is nothing but the introduction to DPDPA, Digital Personal Data Protection Act. Certainly, it is the much awaited privacy law in India. But one word of interest, or one word to draw your attention here. It's not that only during 2023 that India had attention to privacy or personal data. Not that way. We already had a reasonable security practices, procedures, and sensitive personal data information rules 2011, popularly called as SPDI rules, which was part of Information Technology Act. So there, personal data, sensitive personal data, modes of securing them, and best practices to be followed, all were already a party there. I mean, already embodied there. This act is exclusively for privacy, because to be in line with all other nations who have enacted similar legislations exclusively for privacy. So it's not that 2023 alone privacy has come into play in India. No. So we already had it earlier. And it is given that these rules will be repealed once the DPDPA rules are pronounced. The Act says that this rule will no longer be there once the DPDPA rules come into vogue. Now, the adjudicating body in this data protection, Digital Personal Data Protection Act, is a Digital Personal Data Protection Board, which is yet to be formed. And then, of course, as I mentioned earlier, the rules which explain which provision of the Act becomes applicable when and to what extent, all these specifics, okay, will get clarity only upon the rules getting pronounced. Two aspects which really lured me while I was going through this act is that this act has complete association, or it's toned in a way wherein there is always a she that is mentioned. In every example, in every reference to explaining the provision, it is her and she. It is a feminine tone that is with which the entire act is put out. So that really makes me feel very warm and very special as a woman. And another important thing which I found very interesting and different in this act is that most of the sections, most of the provisions of the act are accompanied by very simple and easy to understand examples. So the intent of the lawmaker is becoming very clear when you read those examples. You're able to understand the section better. So those are two aspects which I found, that this act really stands out from the rest, right? And now one other aspect which I would want to put forth is that in this presentation for the next, I would say 10-15 minutes plus, I'd be discussing only on the very key aspects of the act, because although the act is just 21 pages, the amount of information that it embodies is quite massive. So I'll be touch basing only on the core aspects with respect to the players which are mentioned in the act, right? So now, first things first, what is personal data? The whole act is about personal data, right? Data about individual, which is identifiable to the individual, as simple as that. That's a one-line definition, very, very broad-based definition. There, they have not given any examples, probably consciously. And then this act is very, very clear. They say this act will be applicable only with respect to personal data in digital form and personal data which has been collected in non-digital form but subsequently digitized. So anything that is only on paper, the act doesn't apply. They have made it very, very clear. Third, processing. We just saw a couple of slides earlier. Privacy is associated with processing. Now they have a whole gamut of words here, which they say mean processing. And if you note, it is an inclusive definition. It says includes. So any activity that is performed in association with a digital personal data, even if it does not fit into the exact definition, it will still be called as processing. So that is again an interesting point out here, right? So moving on, with respect to applicability. Now here, they are very clear. And before I get into this, one aspect of interest, there is a stark difference between personal and person. So here, if I go back, they say personal data is about individual, but definition of a person in this act does not includes individual. It says individual, firm, company, artificial juristic person, so on and so forth. So personal data is different from person. So personal data is about individual. So we have to just remember that, right? Moving on. Now into applicability. Now here it clearly says, if you're processing a digital personal data within the territory of India, royally this act is applicable. If you're processing the digital personal data outside the territory of India, and if such processing is in connection with goods or services to a data principal who is situated within the territory of India, yes, it is applicable. If not, it is not applicable. And two other areas where it is not applicable at all. For domestic and individual purposes, if you're going to process the data, like I have a new car, so I'm going to get a new driver. A friend referred a driver to me. So I'm a skeptical person. I don't trust anybody. So I asked him for his phone number. And I also asked him for a copy of his Aadhaar. It's a pure domestic individual purpose. This act does not apply. Personal data is made or caused to be made publicly available. I'm a blogger. I love social attention. So I tag my name to each and every photograph. I put out my personal preferences. I put out my blood group. I put out my, address or anything that is associated with me. I would like to keep it open in the open social media platform. This act doesn't apply. So they've made it very specific and crystallized, right? Moving on. Now on to the key players. Now we have data principal, who is none other than all of us. The individual to whom the personal data relates. In GDPR, we call them as data subject, and here it is data principal. And if the data is going to be, so if the digital personal data is going to be associated with a child, then the principal also includes parents or lawful guardians of the child. And if it's a person with a disability, it includes a lawful guardian. Data fiduciary, in GDPR, you call them as data controllers. Any person who determines the purpose and means of processing personal data. So this is data fiduciary. And processor, of course, anybody who acts on processes personal data on behalf of the data fiduciary. But data fiduciary only is ultimately responsible for any act of the data processor. And you have significant data fiduciary, which is yet to be pronounced. The conditions for being a significant data fiduciary, that is yet to be pronounced by the central government. It could be based on factors like the volume of personal data that they process, the sensitivity, so on and so forth. All this will become clear only when the rules get pronounced. And we have the DPDPA, Data Protection Board of India. The CG, central government will be establishing this board, and the act will lays down the powers of the board, the grievance redressal which can be directed to them, the composition of the board. All the act already lays down. We are just waiting for the central government to pronounce this. And a couple of slides earlier also, when I was mentioning the rules are yet to be pronounced. Yes, the rules are yet to be pronounced. The SFD is yet to be, the significant data fiduciary conditions are yet to be, made clear. DPDPA, Data Protection Board of India, is yet to be constituted. All that is there. But it is better that we start aligning our practices to the requirements of this act. In fact, many of the organizations have already started working towards compliance. Because the moment the rules get pronounced, it's only the race is going to be really, really rapid. So it's better that we start early. So that's one word of attention here. Moving on. Now we get into the key principles of this act. So the first of the principle is consent. And I would say this is the cornerstone of this entire legislation. When I say consent, they have a very, big definition. They say it has to be free, it has to be specific, informed, unconditional. They have lined up a list of, adjectives to emphasize the importance of the fact that it is voluntary and it is free and it is assertive. It is not influenced. That's the objective that they are trying to put forth. And apart from this consent, what they say is that, and this consent, interestingly, it is so intertwined with the second point, purpose. And one of the examples that have been provided in the Act is that, see, I have a telemedicine app and you are the user of the app. I take your consent for making you use my telemedicine app. I also take your consent for accessing your contact list on the phone. You have given the consent. There's nothing that can say that you have not given the consent or consent was obtained by force. No, you've given. But although you have given, just because the consent doesn't perfectly intertwine with the purpose, the consent to the extent of me wanting to access your contact list is invalid. While they place so much of importance towards consent, they are also worried of the fact that it has to be intertwined with the purpose. And of course, the Act itself begins saying that the usage, for the processing has to be for a lawful purpose and it can't be anything against law. So that's a general initialized statement to set the tone of the Act that is provided. And dissemination, we just saw about the data processor. So I may share the personal data which I have collected from you to a data processor for processing. I'll have to do it only with a valid contract. And I'll have to ensure that the processor also has all the security setup which I am required to adhere to, because anything that goes wrong, me as a fiduciary, I am responsible, not the process. So I have to ensure that the security setup is perfect there. And last but not the least, rightful retention and storage. I am not supposed to store the data beyond the requirement of the processing, because I as a data fiduciary, I determine the purpose for processing. I determine the means for processing. We saw that in the definition. So I'll have to also ensure that I store it only for that purpose. And I also cannot store the data if the data principal has withdrawn the consent. Now, one catch point here is, in case by any other law, like I'm a bank or I'm an insurance company, I'm supposed to hold my data for a set amount of period, like in IRDAI, based on the claim payout amount, my storage or the data retention period differs. For a claim of over 20 lakhs, I'm supposed to hold the data for 12 years as per the IRDA guidelines. So if in between that period, if the principal would want erasure of all of his personal data, I may not be able to do so. Similarly for the banking industry, likewise for any other industry where any other law takes over. So that is one point of difference out here. And again, the Act is very clear. They say I can process personal data on two grounds. One is with consent. Other is with legitimate purpose. Means what? I don't need a consent there. And Section 7 of the Act clearly lays down what are the areas wherein I don't need a consent. Like if something is so voluntary, I go to a medical shop, I say, please, this is my phone number and email ID. If this medicine comes, please drop a message to me. So I have done this voluntarily. There is no consent required. And if I'm supposed to get a government subsidy and I register my personal credential, if the government would want to give me more subsidies on other areas where I qualify, I don't need to give specific consent out there. And for the security and sovereignty of the country, for medical emergencies, medical treatments, there's no need of consent. And of course, for employment. One difference between the earlier bill and this was, or perhaps even in GDPR, the employer-employee is out there. Here, with respect to employment, I don't need a consent, but all other provisions of the Act will apply. Just that I don't need a consent. If it's for safeguarding the interest of the employer or in the course of employment, if some personal data needs to be shared, like if I'm a candidate, I'm applying for a job, I need to share all my personal data, right? So there's no consent out there that is applicable, but all other provisions of the Act will apply. That's the catch out here. Moving on. Now we are coming into the key obligations of the data fiduciary. And this is very, very interesting, these set of obligations, if you look at them. Now, the request to consent. See, we were talking about consent. So here, there is a request to consent, okay, which I need to obtain from my data principal. And this request has to be accompanied by a notice. That is one of the key obligations of a data fiduciary. And this consent, and I mean this notice for this consent either has to be preceded to the request for consent or it has to be accompanied. I have to say in that notice that, see, I am going to process your personal data for 1, 2, 3, 4, 5, 6 purposes. And you have a right to withdraw your consent. And, these are the couple of important aspects which I have to mention in my notice, which goes either along or before the request for consent. And in the consent, both the consent and the notice, I'm supposed to give them in English language and any other language together. I have to give them language options so that it is absolutely clear for them. And I also have to give them, wherever applicable, I have to give them the data protection officer's contact details or any other contact detail of the data fiduciary. Because if they are not clear about some of the rights, if the data principal is not clear about some of the rights that they are entitled to, they can get in touch with this person to understand and then provide a consent. So that is extremely important. So all this is for the data that is to be processed after the advent of the Act. Now, what about data that is already there? This is the, a very, very important point which everybody will be interested in. So what about the data for which personal data which I've already collected? So there the Act says, here, if you have a clear consent, then you can send the notice within the reasonable time. All this will be, the timeline and all will be pronounced in the rules. If you don't have a consent, then you cannot process it. So you must ensure that whatever you have already does have a consent at all for you to even continue to hold it. So that becomes important. And again, one of the important players in this Act, which is very special to this particular Act alone, is a consent manager. It's a role. It's a person again. It can be a company, it can be a firm, it can be an individual, it can be anybody. And this consent manager is specifically has to act on behalf of the data principal and has to be accountable to the data principal. So this is with respect to consent. The other obligations of data fiduciary are, I have to ensure that I reasonably secure and safeguard my the data, the personal data. Then I have to have my technical and organizational measures, and any breach, I have to immediately notify the data principal and to the board. And grievance redressal, which is extremely important. The data principal has to have grievance redressal first with the data fiduciary. If it fails, only then they can go to data protection board. And of course, I'm obligated to erase data upon the principal withdrawing consents. Some quick insights on the rights of data principal. Of course, right to access. I can ask the fiduciary for what you are processing, show me what you're processing, what the processor is processing. I can ask all of that. And of course, I can ask for correction and erasure. If some data is incomplete, incorrect, I can ask for correction. And grievance redressal, as we just mentioned, it's part of the notice itself. I can make use of that. And I have a right to nominate. In case of death, in case of incapacitation, I have a right to nominate anybody who can take over and have my rights on my behalf. Then duties of a data principal. This is very, very interesting in this Act. It is not just one-sided. It is very balanced, I would say. There cannot be suppression of any material information while I'm giving out my data. And I'll have to comply with all the applicable laws. And there can be no false or frivolous complaints. Just because I have a right to grievance redressal doesn't mean I can give frivolous complaints. And whenever I'm asking for correction, I have to give verifiable, authentic information. That is very important. And I can never impersonate others. And interestingly, if you go over to the next slide, for a moment, I will draw your attention to the last line of the box. There is a penalty to the data principal if he does not perform his duties. Most balanced approach, I would really say. A quick wrap up with significant data fiduciary. Why? I mean, they are yet to be pronounced. The norms are yet to be pronounced. But once the rules come out and a significant data fiduciary is pronounced, they are supposed to do these 4 requirements, which is not applicable to a data fiduciary. They have to appoint a data protection officer, perform a data protection impact assessment, perform independent data audit, they appoint an independent data auditor and perform periodic audit, all for the personal data. And we have loud, hefty penalties, which will possibly act as a very big deterrent and ensure absolute compliance to this legislation. If the data fiduciary does not safeguard or prevent the personal data breach, 250 crores penalty. It can extend up to 250 crores. And then if the notification about breach is not provided to principal or board, 200 crores. You have additional obligation with respect to children. Like you cannot, do any behavioral analysis. You cannot do targeted advertisement. You can't do all that. So in case you're found to be doing all that without specific requirement or permission, then your penalty can extend up to 200 crores. And as a significant data fiduciary, on the left, you're supposed to do certain things, DPO, DPIA, audit. If you don't do any of those or all of those, 150 crores, up to 150 crores. And this is a wonderful blanket penalty which they've given. Breach of any other provisions of this act or rules made thereunder, max may extend to 50 crores. So I'm sure once the rules are pronounced, this act is sure to be a game changer. So let's all brace ourselves, prepare ourselves to get this together and respect the privacy of each other. So I'm done with my content, and I'm gladly handing it over to Chudamani, my counterpart, who will be taking you over on the applicability, the implementation, and a scheme of other interesting aspects. Thank you so much for patient listening up till now.
Thank you so much, Sangeeta. Looking forward for Chudamani. As I have mentioned in the chat, we do have a lot of students joining us. So in case there are any questions, I'm sure you would be glad to update us on that. Over to you, Chuda.
Yes, thank you so much. Is it like, exactly at 5, it's just going to go off, the screen is going to go off, or will there be a consideration of some more time? Not sure, because I have to choose my slides accordingly. It's already 5:45, 5:46.
Please go ahead. I think we can do it for 15 minutes more, not in a hurry.
Okay. Right. So I will start sharing my screen. Is my screen visible?
Not yet,
Not
Chuda.
yet. Not yet.
No, not yet. Right. Is it okay now?
Yes.
Yeah. Yes.
Yeah. Right. So thanks, Sangeeta. You've set the tone. A totally passionate speaker. I hope to be a worthy counterpart. Right. So I will be briefing you on the application and implementation aspects of the Act. And okay, let's have a brief look at the Puttasamy case, when the requirement for privacy was actually felt in the Indian context, when Aadhaar was the subject of the case. What happened at that time was there was a case was made to uphold the constitutional validity of Aadhaar, and whether everybody has to have Aadhaar. Basically, that's what. See, I mean, that's one of the cartoons in Pinterest. I've taken it. You can see that it's self-explanatory. Everybody is asking for your Aadhaar. So if your Aadhaar is disclosed, all your biometric data, all your personal data can be linked, and they can be retrieved. And so there was a contention as to whether Aadhaar has to be made compulsory. And has to be made compulsory to be a KYC document. And finally, this case, due to the data privacy concept, finally the government said that, the Supreme Court said that Aadhaar can be linked with PAN. Aadhaar can be used, it is necessary in the case of government subsidies. But you cannot ask, suppose I want to open a bank account. The banker cannot insist that I need to have an Aadhaar, or he cannot link my mobile to my Aadhaar. And again, private companies are also taking it left, right, and center. So they again were forbidden after this Puttasamy case. That set the tone for privacy, actually. And subsequently, a lot of development has taken place. But before, we actually start off on the application and implementation aspects, I would urge all of you to please understand the fact that, each sector is governed by its own cyber laws and regulations. So you have the All-Engulfing Information Technology Act, read with the rules. As Sangeeta mentioned, you have the reasonable security practices and procedures, sensitive personal data information rules, and which read along with the Information Technology Act will give you a lot of insight into how privacy is applicable in the practical context. Like, for example, there was a question also on whether telephone calls can be recorded, or you go to a shopping mall and you have CCTV surveillance cameras everywhere. There are regulations for these also, that you can record. You can probably use it as a surveillance tool, but you cannot use it for processing. Like, for example, I'm standing at the counter of a mall. My billing is at 7:30. Invariably, for redemption points and things, they ask us for our phone number. Have you noticed that? So we very willingly share our phone number, our name and things like that, because we want those redemption points, right? So 7:30, I'm billed. 7:30, my camera captures my image. Okay, if the surveillance camera data is processed and the two are linked, okay. So the word here is processing. If it can be proved, okay, that the two together have the bill data and the image, my personal image captured through the surveillance camera, have been linked at some point, then there is a breach, unless there has been a consent for this. Okay, so this is something we just have to know. The processing part is very important. So having said that,
Sudhamani, sorry to interrupt. Yeah. Could you just go in slideshow mode, so that, because the slides are really small.
Okay, slideshow mode.
Down below on that panel near the Zoom. Yeah, the next one. Like a TV screen. Yes.
Sorry. Actually,
Thank you so much. No worries. Thank you so much.
So again, Sangeeta already mentioned these to you. So when it comes to implementation, all the obligations of a data fiduciary come from the rights and duties of the data principal. Rather, the rights. Let's focus on the rights for the time being. Okay. So if I have a right to, as a data principal, I have a right to access information for correction and erasure, of a grievance redressal, or a right to nominate. That translates into an obligation for the data fiduciary, who is using my data, my personal data, for processing. Okay, fine. Now, so this is very similar to the slide Sangeeta showed you. So these are the obligations of the data fiduciary, the grounds for processing, notice, consent, and all that. Let's take some practical example. Okay, let's say, for example, on a daily basis, how much of our own personal data we are so willingly sharing. Okay, now we live in an apartment, for example, and that apartment has it has its own association registered under the Societies Registration Act. Okay, and we've given them all our personal data, haven't we? They know all our family details, our phone number, email ID, and things. So they stored the data. They could be storing it in Excel. They could be storing it in physical form. If it is again in physical form, no issues. The DPDP doesn't actually come into play, but they are going to be storing our data in electronic form. There is a reasonable cause to believe that this act would apply. So again, they would be using it for invariably nowadays in very large societies. There are a third-party manager. There are third-party managers who are actually managing this data, and so you can expect that this act would apply. And then our ubiquitous mobile phone, okay, which has all our data. So much of it is stored on our mobiles. Okay, we decide to go shopping, let's say, and we book a taxi. We use the mobile app for booking a taxi. What are the kind of data that is that's produced? Your cab app has your personal data. Have you ever noticed that it knows where you last actually, if you frequently been traveling between one point and another, it'll ask you if this is your boarding point and this is where you want to go. And through the GPS, it locates your where exactly you are now. So again, that's data. Okay, so now then you step out of the house. Okay, and many apartments nowadays have biometric locks. Okay, and you use your biometrics to lock the house, and then you have again a surveillance camera. Okay, say smile, and whether you smile or not, it's going to capture your data. Okay, and your taxi comes, and your entire journey is captured. Your GPS traces the location where you are, and then where you're traveling, and you also willingly share it with all our people who are really concerned about our safety. And next would be I can't see it myself. Okay, and then next you do your shopping. Again, there is a camera capturing your all your preferences, where exactly which are the sections of the mall or the shop you're visiting. You go to the billing counter. Again, some time ago, for billing you use your name and phone number. Sometimes we give whatever they ask us for. And in all these cases, if you notice, there is a third party involvement. Okay, if there's a third party involvement, obviously there is some processing done. Okay, because even in your surveillance camera, there is an admin who actually is the custodian of the data. You actually enter into a contract with him, okay, for administering the surveillance camera. So again, so he becomes your data fiduciary in a way. Okay, so these are cases which I thought are practical applications. Again, going forward, every day we use so many websites. We browse through so many sites. So how aware are we? If you've noticed, so many times, so many of these websites ask us to use our Google account. Okay, now because it's so easy for us, we actually don't bother to look. Okay, please, I use my Google login. You can use it. You can use my Facebook login. we willingly consent, okay? And without realizing the fact that Google and that third-party website to whom we have given the consent to use Google, they are in a contract, okay? And they are actually using all of Google's data that we have uploaded. And in fact, I wouldn't be surprised. You'll see in the next few slides, so much of our personal data that we have uploaded on Gmail could be shared, okay, by Google. So we need to pay attention. Actually, I started looking into all these a little more closely after, this act was passed. Similarly, your browser, okay, they collect a lot of information about you. So this is one example where, see, it says very clearly, Chrome notes topics of interest based on your recent browsing history. Also, sites you visit can determine what you like. So we're not surprised, right? We've seen this before. If you buy something on Amazon, you invariably get other suggestions for buying. Okay, so but then you have a choice. What I'm trying to point out is you can make changes in Chrome settings. Okay, you do have a choice, and this is a choice which we can consciously exercise. Okay, and this is one example. I was really shocked. It came as a shock to me. I was searching for a phone number in the Truecaller website. Okay, and Truecaller said, "Yeah, you can. I will tell you who this guy is, who is calling you." And but then I will also take, if you're going to connect me through Google, I will also take all your contacts which you uploaded on Google, and that's what it says. So, and then Google is telling us, in spite of it having a contract with Truecaller, it says, you may be sharing sensitive information with this site or app. You can always see or remove access in your Google account. Learn how Google helps you share data safely and all that. So, it's not, you really have to be a scholar to be able to discern all these disclaimers. It's almost sometimes so mind-boggling for us to keep track of, our privacy. How much time do I have, actually? I've kind of, I'm not even not even halfway through, actually. So Sunita, how is it okay for me to continue, or?
Yes, please.
Yeah, please
Notice it.
continue. Maybe you can take 10 more minutes, and then there are a few questions that we need your answers.
Right. Okay. So from the point of view, this is from the point of view of privacy, and as a data principal, as a data owner, how much how concerned I have to be about data privacy. Now, looking at it from the other point of view, the data fiduciary point of view, like Sangeeta explained to you what processing is. So much of it is processing, But what DPDP concerns itself with is digital personal data. It has to be data, it has to be personal data, it has to be in the digital form, and it also has to be processed. So these are the conditions under which, the DPDP would come into play. So if somebody is like, going to go voluntarily on, do a vlog or a blog or something, and then, discuss all their travel plans and things, I mean, there's no question of consent in that case. Okay. So the third party host would just be, he's just a host again there's no question of our consent being there in that case. So in that case, it's not considered personal data, which would come within the purview of this act. So if there's any breach in that sense, in that context, it would not attract the penalties of personal data breach. Okay. So, okay. Now, for example, there's plenty of data available for a business. You post so much of business data on the net. You have the name of the company, email ID of the company, you have the marketing chief's ID, and so on and so forth. But if it is personally identifiable information, PII is, these are GDPR concepts actually. Like Sangeeta was saying, we still haven't got the regulation, so we rely so much on the output of the other acts implemented elsewhere. If it is saleschief@gmart.com, it is a general email ID used by the sales chief. But if it is meena@gmart.com, okay, you can identify that person by the name. So it becomes personal information. The date of birth of Meena is personal information. So among all the business data that you have, you will concern yourself with those pieces of information which actually help you to identify an individual. Okay, and there are, of course, a lot of terminologies doing the rounds. What's personally identifiable information? What's confidential information? What is sensitive data? Okay, they are not mutually exclusive. Okay, none of these is. So it just depends on the context in which it is used. So the word confidential is used, more in the organizational sense, and levels of confidentiality, and who can view what in an organization chart and things like that. Typically in sales, those organizations which have implemented ISO 27001 would know about this. Then again, sensitive data. Sensitive data is anything that can cause harm, embarrassment, inconvenience, or unfairness to an individual. So I'll just go one step beyond. Okay, see, I do give my name, address, mobile, sometimes the date of birth. Again, that's the act doesn't actually acts elsewhere do not consider it as sensitive data. Your occupation, these are general personal data. They are personal data, no doubt, but they are general personal data. But certain classes of personal data become sensitive. If it's a race or the ethnic background of the person, the political affiliations, genetic data, health information, sexual orientation, your bank account details, these are sensitive personal data. Now, the definition of sensitive is very relevant in the context of significant data fiduciary that Sangeeta was talking about. Some data fiduciary would be classified as significant data fiduciary if they process, in terms of volumes and sensitivity, the personal data they process is of a particular kind. So in that context, sensitivity of the information is very important. And okay, why would we need a law to protect our personal data? How would you like to trust a mobile banking app if you knew that your personal data is not protected, right? So that answers, it's a question which answers your question, if at all you have it in mind. So then, what's the time? Am I okay to go ahead? Okay, another 4 minutes. So again, these are the various tenets of the Act, which convert into duties of the data fiduciary. One illustration given by the Act is the somebody opening a bank account for the KYC. Their data is their video is captured, and for this, the bank has to take consent of the data principal, whoever's being captured on the camera. Okay, the KYC. So, okay. Now this is a consent manager. This is an example of a consent manager. Okay, when you go into a website and you're tracked through cookies, right? You must be knowing about cookies. So when she was talking about clear and unambiguous consent. Now, I thought this is one very good example of cookie information, which E&Y Careers Job Search site has put up. It says very clearly, by clicking accept all cookies, you agree to these. What is that? The functional optional cookies are used to improve your experience on the site, to make it more user-friendly and in line with your needs. In this context, cookies from providers in third countries entries may also be used, which means they are, in contract with other third parties who may be also using these cookies. You can imagine data is the new oil, like that's what you started off with. So you can imagine why they collect our data. And you can select your settings by clicking on modify cookie preferences. Now, if I click there, again, it's so beautifully, they have disclosed so transparently what are the various cookies which are required and which are those which, they are entered into third-party contracts for advertising purposes. And these are technical terms here. SAP as service provider is a provider, and they use session cookies like route, career site company ID, JSession ID, a load balancer cookie. Okay, the techies would understand this better. And then for the advertising cookies, they say these are the ones. This is a widget that allows you to share the jobs across the. So if you have allowed, if you've not modified your preference, all the cookies will be enabled. But if you've chosen your preference, they probably leave out these advertising cookies. Okay, so you wouldn't probably, your privacy wouldn't be invaded to that extent. Again, I was telling you about consent, and consent. After consent comes your other obligations, like what you do while processing, what you do while when you retain data, and so what are the technical and organizational measures to ensure effective observation of the act? The data fiduciary, as an organization, the data fiduciary has to observe certain technical and organizational, they have to take certain steps to ensure that their DPDP implementation is in place. Very first thing would be, your technical measures. This, techies will be familiar with this. You have the detective, preventive, and corrective actions spread over all your information assets like devices, networks, application, databases, users. So if you fill this matrix, you'll have a very fair idea what controls are in place for protecting your data. Okay, and what are the organizational measures? So you have a to-do list. You design your consent form. You'll have to design your notices. Like I just showed you, the cookie consent forms and cookie notices. And then you'll have to appoint a consent manager and a DPO if it's a significant data fiduciary. You'll have to train and make your personnel aware, and you'll have to while framing third-party contracts, you'll have to be very clear. The wording and things have to be. Many people use the cloud, for example. That may also be in your mind. So if the cloud is going to breach, there's a breach in the cloud. Okay, your cloud service provider has a breach. Okay, who is responsible? You entered into a contract. Okay, but you still are the data fiduciary. The fact that there's been a breach with your contractor doesn't mean that the responsibility can be taken off you. He's just a processor for you. Okay, you still hold responsibility for the fiduciary nature of the data. And then what are the other organizational measures? You'll have to design policies and standard operating procedures, give consent for storage, retention, erasure. For all these, you'll have to evolve standard operating procedures. Again, these come from the rights of the data principle. So, and then this again, Sangeeta had covered. So how do you go about inventorizing the data? This is one matrix which helps you to take stock of what data are available with you across databases. Okay. Now I've given the example of you'll have to do a process study. You'll have to study each process one after another, step by step, and extract data which are embedded in these processes, and again classify the data to identify personal data, the level of sensitivity of the personal data, and how you obtain them, whether you got consent, Where have you stored them? Where has the backup stored? Whether you've used pseudonymization or anonymization. I mean, these are concepts I do not know if I'll have the time to explain, like virtual dummifying it in a way, using dummy data. Instead of the real name, you use some fictitious name. That's pseudonymizing. And how long you're going to retain it. So if you do an inventory check of your data across the databases, you will know, you'll probably have a matrix like this. And again, a single process may span across a number of databases. For example, if it's billing, you have the customer database, you also have the billing database. So the two together would help you to go ahead with emailing your bills to customers. And again, the billing database may not have personal information. So again, you're safe there. So there are certain exceptions where, you can go ahead, process data without consent. Most of it has to do with the government, okay? In a nutshell, I can tell you. And I gave the example of a voluntary provision of personal data, in which case, this act would not come into play.
Hey, Chudamani,
Yeah.
Mahesh here.
Yeah.
I mean, a quick time check. Actually, we have 4 minutes past that 6:10. So
Okay.
a quick time check.
Right. Shall I wrap it up here?
Yeah, I think we can go to the questions actually.
All
So
right, fine.
I'll leave the choice to you, but then again, right?
Yes,
quick time check, yeah.
Mahesh, I think that would be better. I thought I was rushing through actually.
Yeah. Right. So.
Sorry, Chudamani. It was going really interesting for the, because we are pressed for time. I think we might be able to take a couple of questions. So I'll hand it over to Parimala. Parimala, maybe you can moderate the chat and then, pick up a couple of questions and ask the speakers, please.
Yeah, sure. Thank you. So we have the first question here. With IoT and chips going to be embedded in humans, how effective would DPDP be? With IoT and chips going to be embedded in humans,
absolutely.
How effective?
How effective it is going to be? Yes, that's something which we'll have to do research. And it's, in fact, as director research, I've taken that up as a topic. I'll be able to answer that in another year's time. Right now, we don't have any regulations from the consumer point of view. There are the regulations for the technical side. Okay, you'll have to be for devices to be put in the market. You have technical specifications, but for the consumer, how safe I am with IoT devices? How is my privacy going to be affected? I mean, your guess is as good as mine. Why would companies, lobby for or would not lobby for an act against their seeking private data? It's going to be a huge unanswered question for quite some time. But let's hope there would be some development with the regulations coming out now. The DPDP board will come out with the rules and regulation. Let's see if there's some mention there. Otherwise, because even across the world, if you see this, only the American context, there is the NIST, which prescribes some framework for privacy for IoT devices. Again, that's voluntary. So there's a lot of that's going to be unanswered. I'm really sorry.
That's okay. So thanks, Chudamani. We are going for the next and the final question, which is, previously we have been using the AWS VM instances to store the organization data, and it is hosted in East US or the West zone, with being hosting in the US zones were cost efficient
and we had only one zone available in India without redundancy. With that being said, as an organization, henceforth, should we ensure that the organization data are hosted in the zones available in India only? Is that right?
Hey, Chudamani and Sangeeta, can I take this question, please?
Yes, please, Mahesh. You would do the justice to this question. Yes.
Okay. Thanikanadan, thank you for this question. Really appreciate it. One of the things which we'll have to go ahead take a look at it here is what are we talking about data localization? So what the Indian government or through this DPDPA says is, yes, you can go ahead, take the data outside the country, okay, but also keep a copy of it here as well, right? And that should sort of answer your question. So in effect, yes, yes and no on the data localization, right? So the proliferation of data centers are certainly going to happen, right? I mean, one of the other things is the adequacy also comes in. Oh, the other country which processes the data, will they be adequate? If not, let's just go ahead, keep it here. But to answer your question, on the without redundancy, keep it here, right? Think about data localization.
Thank you, Mahesh.
If I can also pitch in on the previous question on the IoT devices, there again, I personally feel, all of the mechanism prescribed, in the law, if it is followed, I don't think that's a challenge. No, it's like any other consent mechanism we give for our personal information. So in case of a IoT device put on a individual, for a pacemaker or any other, the data goes into the hospital and the medical this thing, and they will have to follow the norms. I don't think, we will have, a very good risk assessment, risk, privacy risk and other elements done, and technical and other process controls are put in forth. We don't see this as a challenge, and we will have to look at all of these from a safety of people as well. Look at the element of how some of the handheld watches have helped people. When you have a fall, the new generation phones, I'm purposely not using names here, okay, is able to do an emergency call to the healthcare authorities, and people have got saved. We have to look at that, be it GDPR or any other regulations. There is a very clear mandate, or if there is a safety aspect of it, then it takes precedence over the normal aspect of, that's how. But end of the day, they can't keep it free. It is important for the controllers, who is processing these. They have to put the required controls in place to ensure that it is not getting compromised. So be it IoT or non-IoT, everything boils down to the privacy risk. And if we are able to identify the risks and put controls, it takes care of it. That's what in a nutshell I would say.
Thank you, Vaiti. Thank you for the brilliant questions and equally brilliant answers and explanations. It's really been, wonderful listening to each one of you. On a lighter note, yes, I did start saying that data is a new oil, but now it looks like it's a very expensive oil if not protected well. So on behalf of eWIT, I take this opportunity to thank each and every one of you. Special thanks to the speakers for the day, Ms. Chudamani and Ms. Sangeeta. It was really interesting and informative. And thank you, Vaiti and Mahesh and the ISACA Chennai chapter team for bringing in your valuable team members to share their knowledge with us. I would also like to thank each and every one of you who's been, patiently listening to all of us, and though the time got extended, participating. So the audience, thank you so much for taking your time out and being here. Last but not the least, I would like to thank our eWIT committee members who've been ensuring that every session adds value to us. So thank you so much, everyone, and I'm wishing you all a very happy weekend and safe weekend.
Thank you, and once again, thank you for the opportunity, and looking forward for more, joint and collaborations between eWIT and ISACA Chennai chapter. Thank you.
Definitely,
Thank
it
you
will
so
be our
much.
pleasure.
Thanks, everyone. And thank you, Sunita, Esther, Parimala, Ambika, and especially Mahesh here. And Sangeeta and Chudamani, you guys were awesome. Probably we should have had a room full of seminar kind of a thing, not just 1 hour webinar. We'll plan that very soon. And thank you, Vaidi, for chipping in for the answers. It's a great honor to have you all here today. Thank you.
Thank you, everyone.
Absolutely.
Thank you.
Thank you
Thank
all.
you very
Thank
much.
you.
Thank you
very
all.
much.
Nice evening
Bye.
and have a great
Bye.
weekend. Thank you.
Yeah.
Happy evening. Thanks a lot.
Thank you.
Thank you.
Bye-bye.
Happy evening. Happy weekend when you get there.
Same
Bye-bye.
to you. Thank you.